Good morning, good afternoon, good evening. A warm welcome to the discussion today, which will be focusing on the policy on addressing environmental damage through the Rome Statute. I can see our friends and our colleagues are joining in. So I'll give them 1 minute to continue checking in. In the meantime, feel free to introduce yourself in the chat. Also, feel free to check out the website of the Environmental Peacebuilding in the chat, which has more activities coming up. This is just one of the activities under the Environmental Peacebuilding Association, the Path to Ottawa events. So just 1 minute as colleagues continue to log in. Feel free to introduce yourself in the chat and feel free to check out the website for more events that are coming up. Welcome once again. Allow me to start our session this day. Once again, a warm welcome to the session today, which is part of a series of events and initiatives under the Path to Ottawa activities hosted by the Environmental Peacebuilding Association. Our session today will focus on the policy on addressing environmental damage through the Rome Statute, which was launched in December 2025 by the Office of the Prosecutor in the International Criminal Court. The policy is part of our global, regional, and national efforts to address environmental crimes and damage, both in times of conflict and in times of peace. To expound on this discussion and to answer our questions are two of our colleagues who will be speaking to us, James Gondi and Professor Daniela Dondijon. The session is a learning process, so please feel free to engage, feel free to ask questions and to interject as we continue to have this discussion. So before we start, I want us to know that this session is being recorded and it will be posted on the website or on the YouTube channel of the Environmental Peacebuilding Association. Feel free to use the chat section once again to ask your questions, and also feel free to raise your hand and ask questions and also contribute to the discussion. To give us a few remarks on the Environmental Peacebuilding Association is Clementine Grillo, and I will take this opportunity to welcome Clementine before we start. Clementine, please feel free to, it's your time.
Yes, thank you so much, Monini, for the introduction. I'm very glad to be representing the Environmental Peacebuilding Association. Just for a quick introduction, the NPACS, as you know, is global networks that brings together researchers, practitioners, policymakers, and of course, organizations that work at the intersection of environment, conflict, and peace. One of NPAC's core activities is organizing the upcoming International Conference on Environmental Peacebuilding, which takes place every 2 years, and the 4th edition will be held in Ottawa this June. And it's a major gathering for the field that brings together people from different regions, sectors, to share new research, case studies, practical tools, and of course to build partnerships that continue beyond the event itself. As Monini explained, leading up to that conference is what we call the Path to Ottawa. It's a series of events that takes place from 2025 to June 2026. These are either regional, national, and thematic dialogues, roundtable, online events that are organized by NPACS members and partners. And the idea is to broaden participation, surface regional priorities, and especially new perspective. And yesterday's event is part of the Path to Ottawa. If you are interested, there are several ways to get involved. You can participate in or organize a Path to Ottawa event yourself, submit proposal to the Ottawa conference, or simply take part in discussions like today. I've added a few resources on the chat feel free to check those out. Thank you so much, Munini.
Thank you very much, Clementine, for that introduction. And now to our colleagues who are going to engage us in this discussion, allow me to introduce them briefly. First, we have Dr. Daniela, who is a professor of international sustainable development law and director of the Grotius Center for International Legal Studies. Amongst other areas of responsibility and leadership, Professor is a deputy chair of the International Union for Conservation of Nature World Commission on Environmental Law, Specialist Group on Environmental Security and Conflict Law. She is also a visiting professor at Vermont Law School in the US and Nagasaki University in Japan. Her research focuses on a number of areas, which include contribution of international law to shaping the governance of natural resources at the global, regional, and local level, with a special emphasis on conflict prevention and remediation, intragenerational and intergenerational equity, amongst other thematic areas. Welcome, Professor Daniela. Our other colleague who will be engaging with us is James Gondi, who is a human rights and democratic governance lawyer with 2 decades of experience in constitutionalism, international criminal law, and environmental justice. He is currently the executive director at Terra Lex Africa, previously having served as Africa Director for Stop Ecocide International. James' research spans international criminal law and accountability mechanisms, transitional justice and reparations, ecocide and environmental governance, constitutional reforms, and judicial activism, amongst other thematic areas. So we are going to start our session with our colleagues, and we are going to go through a series of discussions through a series of questions. And our first question goes to Daniela. Daniela, having been engaged in this process of the policy on addressing environmental damage through the Rome Statute, could you share an overview of the policy with us?
Thank you very much, Monini, and thank you also for inviting me here today. It's a real pleasure to see you back and also to see new people, and especially this is, I think, quite interesting that there are actually 2 former students of mine here, both Luva and Clementine. So very nice also to see you back and that you're still active. So maybe just a couple of words on the context for the policy paper before I actually go into the policy paper, because it builds on a 2016 policy paper that the ICC, Office of the Prosecutor, published, and where it set out its determination to address environmental crimes. But then from 2016 until now, to be honest, not much happens. And in that sense, I think this policy paper is a welcome development, because it actually, it builds on this original intention, but also sets out in detail what the ICC can do with respect to crimes that are committed either by means of or that result in environmental harm. And so what it actually does, it sets out for all 4 Rome Statute crimes how these can be committed by means of the environment or can result in environmental harm. And as such, I mean, there's no suggestion for adding an additional crime. So ecocide is, of course, under discussion, and I assume, James, you're going to address that. But that is not what the policy paper does. So it really focuses on the existing crimes in the Rome Statute and their connection with environmental harm. What is quite novel is a number of aspects, and that is first, its definition of environmental damage, which is quite ecocentric in a way, in the sense that it also includes in the definition of environmental damage impact on the health and well-being of ecosystems and its non-human inhabitants. And so in that sense, that it really engages with the environment and its intrinsic value, and not just the connection between the environment and human harm, which might have been expected from the Rome Statute, and it's focused normally on human harm. So in that sense, it's more inclusive. And that also relates to the gravity assessment that the Office of the Prosecutor intends to do, because then they also say that they may consider damage to the environment as such as being relevant, looking at scale, nature, impact. And so it really goes beyond harm to humans. So it seeks to address crimes that impact the environment, notwithstanding its connection to human harm. So in that sense, I think that's a novelty compared to what most of us expected of the Rome Statute. And what is also very important, but we may come back to that, is the notion of positive complementarity and how the Office of the Prosecutor intends to use that in that context. But maybe I'll save that for later.
Thank you very much, Daniela, for those insights on the policy. Allow me to engage James at this point. James, generally, what are your thoughts, having heard Daniela's presentation on the new OTP-ICC policy?
Yes, thank you very much. And Daniela did point out a very important part about this policy, in that it moves beyond the anthropocentric. That is the view of the environment not only being important when the harm attaches to human beings. It goes to an ecocentric model where it notices and recognizes the intrinsic value of the environment in and of itself. It's the first, I think this OTP policy on environmental crime is the first systematic framework for environmental crime prosecution that we do have. There are other recommendations, such as the recommendation on ecocide, which has been brought forward by the small island states of Vanuatu, Fiji, Samoa, that proposes a fifth crime of ecocide. Ecocide being wanton damage of the environment that causes irreversible harm. And there's an international legal panel of experts that has created that definition of ecocide law. And that's a new, innovative way. I think what the ICC prosecutor's policy does, it brings us one step forward in terms of the punishment and individual criminal responsibility for environmental damage that is widespread and systematic, even before we have a fifth crime of ecocide. So I don't see it as a replacement to the fifth crime of ecocide that we so desire in our movement, but it's a step, it's a first step, and it's a recognition that nature itself has an intrinsic value that needs to be protected, both in times of war and in times of peace, and not for the sake only of nature's value to human beings, but nature's intrinsic value. Now, this intrinsic value appreciation, I think, coming from an African perspective, really resonates with African philosophies such as Utu and Ubuntu. And those African philosophies state that I am because we are. Now, the environment does not exist on its own, neither do human beings exist because of the environment. Human beings need to be protected, but so does nature. And nature in itself, in the Ubuntu philosophy, is part of the ecosystem that must be protected regardless of the human value of that protection. We also go to international humanitarian law, where we have seen historically that armed conflicts often involve environmental destruction. Now, what the ICC OTP prosecutor's policy does is that it recognizes some of these historical harms to the environment that have been neglected in times of conflict, and recognizes the fact that this needs to be redressed historically. So I think this is a very important innovation. The policy acknowledges the actus reus in law. That means the action of the crime, which is destruction, degradation of the environment, and it's treated as conduct qualifying under an act of international crime or atrocity crime under all four of the Rome Statute crimes. That is genocide, crimes against humanity, crimes of aggression, and the other crimes. It seeks to remedy historical neglect and candidly acknowledges that environmental crimes have been under-prosecuted, and it now shapes case selection criteria and the gravity around the environment. The other thing that the prosecutor's policy does, which we have sought to do also under the ecocide law movement, is explicitly target supply chains and corporate accountability. Who is involved in the supply chains that cause mass harm to the environment that is irreversible in nature? Which are the investment portfolios? Who are the particular corporate officers? And that speaks to Article 25 of the Rome Statute, which speaks about individual criminal responsibility to be attached to companies and to be attached to corporate entities, and command responsibility, where there are either corporate or militia attacks on both human beings and the environment in the context of international crime. So I'll stop there so that we continue the discussion as it flows. So I really recognize Daniela's contribution as being close and sequential to my additions around historical neglect, ecocentric and anthropocentric approaches, as well as corporate accountability.
Thank you very much. A big question that has always been asked is about the corporations. Every time we have discussions on environmental degradation and damage, the corporation question is always coming up, especially in the global south. So is this policy, with this policy, does that mean corporations can now be prosecuted? And also with the question of corporations being located outside the global south and working in causing the damage in the global north, or corporations located in one country causing chaos in another country. Does this policy, what does the policy say? What do we expect of this policy or the provisions?
I think this policy will really help, because what it does, it shifts, it really changes the game in terms of creating the opportunity for individuals within corporations to be prosecuted. Those who issued the orders. And if you look at it from the traditional Rome Statute approaches to international crime, we could call it command responsibility. In the past, corporations were able to hide under their corporate veil and say that a corporation is a legal entity in itself, it's a legal person. And that we learn in company law and corporate law. But in this case, in both in the ecocide movement and within the prosecutor's policy, it targets now individuals within corporations. So those who make the decisions. What this will do will first of all raise the bar in terms of due diligence. When a company is doing due diligence, it will want to evade prosecution for international crime. So that corporation will therefore do its due diligence and consider, even in its environmental impact assessments, where there is a possibility of crime and try to prevent that. That is our hope in terms of the normative approach, and that is the hope of this policy and ecocide law in terms of deterrence. We want to deter individuals within corporations from signing off on decisions that might pollute the environment in a wanton and irreversible manner. However, even before we go to ecocide law, individual criminal responsibility is a critical part of the Rome Statute. So it will open up individuals in big corporations who are often in the global north, companies based in the global north, signing off on mining and extraction and other corporate activity in the global south that is harmful to the environment and harmful to human beings. So it will open them up to the possibility of prosecution at an international court. So the normative values of the International Criminal Court and the Rome Statute via this policy now create a level of deterrence, but also strip the corporate veil when it comes to individual criminal responsibility for environmental harm. So I think this is a very good new opportunity and an advancement in terms of prosecuting corporate actors who are responsible for mass harm to the environment.
Thank you. Daniela, yes, please go ahead.
So no, I agree very much with James that this is monumental. I mean, there have been, of course, discussions within the ICC already for since its very start, or even before its start, about prosecuting corporate actors. And as we all know, ultimately, corporate responsibility was not something that has been included in the Rome Statute, but the option of prosecuting corporate officials has always been out there. And even Ocampo, going back to prosecutors, basically already mentioned that it would be of high importance to indeed go after corporations, because they usually provide the means for committing crimes. And by stating now firmly that individual corporate officers may be subject to prosecutions, I think this is an important step. And besides looking at supply chains and minerals, for example, also think about land grabbing, for example. That big agro companies that grab land of local communities is also a huge problem, and that might be addressed through this policy paper, or in any case through the Rome Statute crimes. There's one caveat, and that's of course that the ICC only has jurisdiction over individuals that are where the state party of nationality is a member to the ICC, or where this happened on the territory of a state party. So that's of course an inherent limitation, but I think for the majority of corporate abuses, it will still be able to prosecute corporate individuals, either because the corporation is located in a state that is a party, so European states are, for example, all parties, or because it's in the territory of a state party. I mean, just to give an example, China is not a member of the ICC, but if a Chinese corporation would commit an international crime on the territory of a state member, for example, in Africa, then the court would also have jurisdiction. So in that sense, I see possibilities.
Thank you. Another question that would come in reference to the jurisdiction. Many times environmental crimes and damage are not confined to the borders of a country, but ecosystems. So, and these ecosystems go beyond political borders. How would such a case be? How would such a case be addressed under this policy and the ICC?
Yeah, that's a difficult one, in the sense that, of course, I mean, to the extent that the damage occurred on the territory of a state party, the ICC would have jurisdiction. But the part of the damage that occurs on the territory of a non-state party, that's of course going to be difficult unless the perpetrator is located in a member state. But there might also be creative solutions. I'm thinking of a very different situation, Myanmar, where, of course, many of the Rohingya fled to Bangladesh, if I'm not mistaken. And that is a state party, so that also offers some kind of a jurisdictional tie. But yeah, there's still the jurisdictional limits that I think is difficult to overcome.
Thank you. James, you wanted to add something to that?
In terms of jurisdiction, I think when we get to the level of international crimes, we have to consider the fact that some of the armed conflicts that have taken place, first of all, are across jurisdictions. For example, some of the crimes that Charles Taylor committed and that he was prosecuted for although he was based in Liberia, there are other atrocities that he was responsible for that took place in Sierra Leone and other places. It's important as well to acknowledge that this particular policy of the Office of the Trial Prosecutor focuses on the individual and their criminal responsibility. As Daniela said, there are some limits in terms of jurisdiction, whether you're a member state of the ICC or not. But however, I think we can apply the doctrine of systemic integration of treaties. International law ought to be read together. And there are some treaties, for example, and some practices and jurisprudence that fault states for causing environmental harm across jurisdictions. And this has been seen, although I can't remember the particular cases, in American case law across states. So even the basic doctrinal case in tort of Rylance versus Fletcher says that if a crime is committed or a toxin is committed on my property, but it does affect the property of the next person, then I am still liable for the effect of that damage to the environment or to the property, whether it's through toxic waste or dumping. So we ought to use some of those examples in tort and apply them effectively. When you come to the Vienna Convention on the Law of Treaties, some of the treaties around the environment that are transboundary in nature can be read together with the Rome Statute and these policies under the Rome Statute, including the proposition around ecocide law to be transboundary in nature, where they affect mass ecosystems, because ecosystems themselves are transboundary, where there be rivers, where there be lakes, oceans, and so on. The other thing I think this particular policy of the prosecutor does is interpret the Rome Statute in light of all relevant rules of international law applicable in the relation between parties. So there are other laws beyond the Rome Statute that are applicable between countries, between states, and that are transboundary in nature, and that the doctrine of interpretation under the Vienna Convention requires us to read the Rome Statute in tandem with those particular treaties that exist under environmental law and they're transboundary in nature. The proposition on ecocide law also recognizes transboundary harm. It recognizes transboundary harm. So when we get to that level, we will be able to hold individuals accountable under the Rome Statute for transboundary damage to the environment.
Thank you. But does the confinement of the policy to the 4 crimes of the Rome Statute create a challenge, especially in the application of these other laws and also in achieving the threshold for prosecution?
Daniela, do you want to take that for me?
Yes, please go ahead if you like.
Do you repeat the question, Munini, sorry.
Yes, I'm asking, does the confinement of the policy to the 4 crimes of the Rome Statute, because the policy is addressing the 4 crimes of the Rome Statute, does this confinement create a challenge in the application of the laws that you're mentioning, or even in achieving the threshold for prosecution for these crimes?
Shall I share some reflections first?
Please do.
Because I'm really dying to talk about positive complementarity.
Okay, yes. Please do.
Because it's, I think it's a key aspect of this policy paper. So of course, the focus of the ICC is on these 4 crimes, and under positive complementarity, of course, states have the obligation to prosecute, and only if they are not able or willing, the ICC comes in. But it goes beyond that in the sense that states, of course, themselves are expected to prosecute, and not just for these 4 crimes. It can also be beyond that, and that is something that is specifically addressed in this policy paper. the role that the ICC can play in helping states with domestic prosecutions, and not just for those 4 crimes, but also for other national crimes, including, of course, for those states that have adopted it, the crime of ecocide, but it can equally apply to other environmental crimes. So in that sense, when it comes to those 4 crimes, then and especially if the ICC itself comes into play, then of course we're focusing on high-profile individuals, on the most serious crimes. But there's also so much that goes below that threshold, but that can be addressed through domestic institutions. And there, this whole intention of the ICC to appoint focal points, to share information from investigations at the ICC that may be relevant for addressing other crimes, including crimes that only apply at the national level. I think that is where the real added value is of this policy paper, in addition, of course, to the more symbolic recognition that the ICC can play a role, which is, of course, important from the perspective of deterrence. But I see most of the value actually occurring at the domestic level.
Thank you. So, James,
could I just add to that? I think in terms of positive complementarity, there will be a big role for the ICC to play, being a court of last resort in terms of inspiring member states to set up national mechanisms for prosecution of environmental crimes. Just as it has helped national jurisdictions to set up international crimes divisions, hybrid courts, war crimes chambers, special war crimes chambers like in Bosnia and Herzegovina, International Crimes Division in Uganda and other places. I think this will be an inspiration for environmental crime to be included in national jurisdictions and the normative frameworks established with the cooperation and support of the International Criminal Court under this policy.
So is this a positive development or an enhancing development for transitional justice?
I think for transitional justice, this is a policy that enhances accountability on one section. The Office of the Prosecutor is now tracing supply chains. For example, if a CEO signs off on a project that they know will displace an indigenous group by environmental destruction, they can be held liable for other inhumane acts. The corporate veil, therefore, is not an absolute shield in the face of mass ecological damage. So this is good for the environment, but this is good for transitional justice, because transitional justice seeks to redress legacies of atrocity crimes. Now, some of those atrocity crimes have been committed against the environment historically as well in terms of reparations. If we begin a policy of prosecuting and seeking accountability for mass environmental crime, including crimes going back to the Leopold time in the DRC, where there were genocides related to environmental exploitation. The reason why the Belgian government at that time and King Leopold himself was involved in atrocity crimes against human beings in the Democratic Republic of Congo is because he wanted to extract as much as possible. So he punished the soldiers and the slaves by cutting off their arms if they didn't comply with instructions to mine. So environmental destruction by corporates has a historical genocidal effect as well, which is punishable not only under the Rome Statute but also under other aspects of international law, including international humanitarian law. But it takes us also to the issue of reparations, which is very important in the transitional justice framework. But also, we need to have around the environment opportunities for truth-seeking, healing, opportunities for repair to the environment caused by corporate actors and individual actors in cases of both in wartime and in peacetime. So it enhances transitional justice because the broad array of transitional justice options, including truth-seeking, healing, reconciliation, accountability, can all be found in destruction to the environment. So as we look at repair to the environment, we'll also look at healing, truth, and reconciliation around environmental harm, in addition to the human aspect. So we combine in transitional justice both the ecocentric and the anthropogenic.
Thank you. I welcome our participants to pose a question in case they have a question. Thank you very much to our presenters for those insights. Another question that comes through is the Rome Statute criminalizes attacks on civilian objects. So the question is environment considered as a civilian object? And if so, why hasn't the ICC considered the environment since it started addressing matters of
I'll
crime?
just start on this, and then Daniela can help me. I think in international criminal law and its beginnings, there was always a very big focus on the atrocities committed against human beings. And even when we try to look at environmental harms committed, we often attach them to the harms of the environment that affected human beings. This policy is also informed by the need for a fundamental philosophical shift in international criminal law to focus not only on the human related harms, but also the harms to nature itself. So the focus shifts from harm to humans and also harms to nature itself. The victim groups then also shift from human beings or groups to ecosystems and non-human species. The triggers as well, there's, as you mentioned, the ICC looks at property damage or human suffering, but this policy, being also ecocentric, looks at widespread, long-term, and severe damage. Now, I would add, as a champion of ecocide law, that ecocide law further protects us against, further protects the environment as an intrinsic aspect of international criminal law. But this particular policy moves us closer towards there. Mark Drumbel, who is a renowned academic, argues that mass atrocities are often conformist behaviors within a system. In an environmental context, this applies to corporate state systems where slow violence, cumulative, and non-immediate harm, like deforestation, is treated as a standard business practice rather than a crime. So this is where the policy takes us, where environmental crime or environmental harm was treated as something systemic or standard business practice that can be offset through traditional litigation and keep people in court. It's now criminalized. So there's a shift in terms of thinking. In terms of contextual thresholds that you asked about, there is jurisprudence from the International Criminal Tribunal for the former Yugoslavia, which says that the widespread or systematic requirements for the crimes against humanity is now being applied to environmental destruction. And this is particularly important in the context of water infrastructure in Gaza. So the International Court of Justice as well, in the cases that are before it, South Africa and other cases, are now looking at the infrastructure damage to water in Gaza, the Nord Stream pipelines, and other objects that were damaged that are partly part of our environment. So the OTP policy is very important in terms of moving our mind shift towards looking at international crime, not only as crime against human beings, but also crime against the conditions under which humanity persists, and that is the environment and the ecosystems. I would add to say that in South America and other places, they've even attached legal personhood to certain ecosystems and given them a legal authority under trusteeship and allow them to sue and be sued. So the Latin American jurisprudence also offers us an additional barrier against this widespread type of ecological harm.
So adding to that, I think I very much agree with so this shift, looking at it from a more historical perspective. I think there are a couple of things that you need to take into consideration to ask yourself, why is it that only the IC only now focuses on this? And I think one aspect is that the court in its first years really focused on the core atrocity crimes, very much focused on harm to human beings. So that's also, of course, a bit of a learning process in the sense that the court itself and also needed to develop in a way. And second, I think even though there have always been calls for the court to address environmental harm, in terms of acceptance and thinking about environmental harm, a lot has happened in the past decade. One such thing is indeed the definition of a civilian object, because for long there was this argument in the literature with respect to IHL that there was this prohibition of causing widespread long-term and severe damage to the environment, and that was the environmental provision, and it was actually an exception, and therefore the common notion of civilian objects did not apply to the environment. So that has also been for a long time a dominant view that changed over the past decades, with the ICRC actually taking the lead, saying the environment is a civilian object. That was picked up by the ILC in its principles on protection of the environment in relation to armed conflict. So in that sense, that's also a relatively new development, saying yes, there's this particular provision on the environment, which is also a war crime, but it also falls under the general protection of civilian objects. So that's one. And I think also, if you look at how human rights law evolved over the past decades, where it really took an environmental turn, that's also relatively new. So I also see this within these developments that occurred outside of the ICC, but that have shaped, of course, the way the ICC has approached environmental harm, and also explains why it has taken such a long time.
Thank you.
Thank you.
I'd like to add that this offers us an opportunity, the moment of this OTP policy on the environment, an opportunity or dynamic interpretation of international law. The Rome Statute really must be read alongside other international instruments, and that's the Paris Agreement, for example, the UNFCCC process, which is the UN's recognition of the right to a healthy environment. So if we read the Rome Statute together with the Paris Agreement and the right to a healthy environment, we then introduce individual criminal responsibility to perpetrators of crimes against the environment itself. So even if we don't have the perfect text in the policy and we don't have yet an ecocide law, we are able to interpret these treaties dynamically and read them together so that we offer the criminal aspect under the international under the Rome Statute and other treaties applying to international criminal law, to the right to a healthy environment and the Paris Principles.
Thank you. Another question is raised about environmental defenders. How does the policy seek to address the question of environmental defenders, or even indigenous peoples who are being harmed trying or in the efforts to protect their ecosystems? Does it speak about these people?
I can't remember whether, I think indigenous peoples are mentioned in the policy paper, but in any case, there are two crimes that are particularly relevant. One is genocide, to the extent, of course, that there is an intention to destroy an indigenous people, for example, by making their conditions of life so harsh through environmental harm. So that might be one. And the other is crimes against humanity. And I'm specifically mentioning these because I'm assuming that we're talking about a situation that does not fall under an armed conflict, and so that war crimes are not applicable. So crimes against humanity is also very relevant, I think, when it comes to environmental defenders. Of course, one of the acts is murder. It has to be part, of course, of a large-scale attack on a civilian population with an organizational element. So you do need the contextual elements, but I think depending on the situation, there may be instances where these provisions can actually be applied to environmental defenders and indigenous peoples.
James,
I also think that this particular policy does mention indigenous peoples' rights as one of the targets that it seeks to protect, because wanton damage to the environment often displaces indigenous peoples who are best placed to defend the ecosystems that they live in, because they rely on them. And this has been recognized by the African Commission on Human and People's Rights, but it has also been recognized by other international human rights treaties. But also, if we look at the dynamic interpretation and look at the Rome Statute establishing the International Criminal Court together and read them with the UN Declaration on Human Rights Defenders of 1998, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Declaration on the Promotion and Role of Human Rights Defenders and Their Protection in Africa, and the American Convention on Human Rights, including other treaties such as the Aarhus Convention. There are several treaties. Now, the Rome Statute must be read together, and so must this policy. It must be read together with those other treaties that seek to protect the environment. And in protecting the environment, indigenous peoples are some of the most affected communities when there's mass harm to the environment. So if we think about it in those terms, yes, it does really affect the indigenous peoples, and there is a mention of it in the policy.
Thank you. Down to our final question. As practitioners who have been involved in this policy or who have engaged with this policy, what are the areas of it start looking into?
Could you repeat the question?
You are practitioners, and you have fellow practitioners who are also looking at this policy or who are wondering, what are the areas of engagement within this policy? What is our entry point, or is it just a high-level global document that we will only engage when we have an ICC case coming up? Are there entry points for other practitioners?
I think the entry points in terms of academic writing, first of all, a lot of research needs to be done on how this policy affects the evolution of international environmental law. So for environmental lawyers and those interested in environmental policy, there's a lot of research to be done in terms of how this can can expound on the jurisprudence of international environmental law. It also offers an opportunity for those practicing in the area of international criminal law, the opportunity to engage with matters to do with the environment, because they are often seen as distinct: international environmental law and international criminal law. This policy offers the first framework officially through which these two are intertwined. I would also encourage practitioners to read and look a lot about ecocide law, which proposes an entirely new fifth crime under the Rome Statute that addresses widespread ecological harm that is irreversible. So there's an opportunity for research, for scholarship, for legal innovation, public interest litigation. I would like to see some cases from Africa being brought around damage to the environment. At the African court, there is the case of Litho versus Ivory Coast, where there was mass environmental harm that, in fact, I think parts were transboundary. And the court ruled that there is liability on the part of the state by failing to prevent the environmental harm against those waterways from being failing to protect the waterways that were damaged by toxic waste through lack of proper environmental impact assessments, lack of proper due diligence, and lack of enforcement of national laws and obligations. But in addition, the African court in that case also required and recommended additional investigation and prosecution of the perpetrators of international crime. That was a recommendation made to the state of the Ivory Coast to conduct investigations and prosecutions. So I think there is a lot in terms of innovation in law, in terms of public interest litigation, in terms of testing the legal limits of the African Charter on Human and People's Rights, the European Convention, the Latin American Convention, the International Convention on Civil and Political Rights, the provisions of those conventions on the right to a healthy environment. There's an opportunity as well to look at first, second, and third generation rights together in a bid to protect the ecosystems that sustain human life. And that's the way we need to look at it, that without these ecosystems, there would be no human life. And not look at it purely from the old prism that protection of the ecosystems should only be undertaken to the extent that it damages existing human life.
Mm.
So I'm not a practitioner. I'm an academic. So my practitioner side is mostly within IUCN, where of course we engaged also with this process by submitting views on the draft policy, and we participated in the launch event. But in terms of follow-up, I think the very fact that this policy paper places emphasis on the links between Rome Statute crimes and the environment, and so looking at environmental crimes will provide opportunities for bringing instances where harm to the environment is brought to the attention of policymakers, and first, of course, there's where there's a clear instance as an NGO, you can consider bringing that case to the ICC and to the OTP, and well, then of course it's not immediately a question of whether they will continue with that, but in any case, that's an option, I think. But also at the domestic level, just by placing more emphasis on the environmental dimension of international crimes, I think is very valuable as an entry point for NGOs to start a discussion and to try to indeed bring those responsible to courts. So in that sense, I definitely see possibilities for bringing this into practice at different levels, and I see an important role here for civil society in catalyzing that.
Thank you. Thank you very much. Thank you to our presenters and our colleagues, James Gondi and Daniela Damdijon, Professor, for the discussion that we have been having. So to close this session, I would like to give you an opportunity to give us your final remarks. What will be your final remarks in this session be? Of course, we'll continue to have this discussion. The policy document is new, so we will keep monitoring how the implementation goes on and continue enriching from an academic perspective, from a practitioner's perspective. But for now, what would your final remarks be?
I think my final remarks would be in form of a recommendation to the listeners At the national level, we need to popularize this policy. We need to have abridged versions of it for purpose of dissemination. The way to get high-level policy documents localized or domesticated is to ensure that they're widely available, they're easy to read, they're on the internet, they're broken down into social media. Just create awareness in your country about this policy. If you've already been working on international criminal law, ensure that this policy is part of your work in popularizing accountability for international crimes in any way, and try to perhaps develop localized policies around environmental crime. And realize, just to conduct sensitization, that environmental crimes can actually be punished by courts of law, in courts of law, whether it be the International Criminal Court, but regional courts as well, but also national courts, if we create the enabling legislation by domesticating the treaty, but also creating enabling legislation that is inspired by the policy on environmental crime by the ICC.
Thank you.
Yeah, I would like to echo that to some extent. I mean, I think if you consider that the 2016 policy paper was welcomed so much, but then nothing happens, of course, that is something that we need to avoid with this much more detailed policy paper that really provides good anchor points for going forward. So I think there's not just a responsibility for the ICC to bring it forward, but certainly also a responsibility for all of us to raise awareness, to engage with the policy paper, to come into action and try to get local authorities moving. So in that sense, I would really like to concur with James, and this is really a call for action.
Thank you. A call to action as the new policy takes time to be implemented. Thank you, Dr. Daniela Damjijong, Professor of International Sustainable Development Law and Director of the Grotius Center for International Legal Studies, and James Gondi, a human rights and democratic governance lawyer. Thank you so much for the insights that you have shared in this discussion. Allow me to also thank our participants for their time, taking their time to log in and to listen to this discussion and to share questions. I also want to thank our technical team for the support, and also thank the Environmental Peacebuilding Association for the platform they have provided us that we can have this discussion. We do look forward in the future to ongoing discussions on the implementation of the policy, on how it's addressing environmental damage through the Rome Statute. Until next time, thank you so much, and God bless and keep well. Thank you. Bye.
Thank you very much, Monini.
Thank you, everybody. Goodbye.
Goodbye. Thank you.